Everyone, I have the pleasure of introducing a longtime friend of legal hackers, the General Counsel of Vroom, and a member of the Advisory Board of Legal Hackers, Sarah Feingold.
Hi everyone. Is everyone seated and really excited for the last part of this day? Is everyone... Your belly's full of pizza. Is there any alcohol in anyone's system? Because my talks are always a lot better when people are drunk. Anyone? Yeah? Okay, good. One person. Hi, thank you so much for having me here. I am a longtime friend of the Legal Hackers. It's an honor to be here. What, am I doing something wrong already?
I'm just going to adjust the mic.
I'm really good at breaking the rules really quickly, you guys. And I'm an advisor to this amazing group, and they've put on such a great international summit. So, let's do a round of applause for everyone here, because I know how much work gets put into this. So, good job. All right, bye. That's it. Anyway, why am I here? So today I'm going to talk about my career path to Etsy. I was the first lawyer at Etsy, and I was there for over 9 years. And then I'm going to talk about why I moved to Vroom. I'm currently the General Counsel of Vroom. And along the way, we're going to talk about the 5 lessons that I learned. And guess what? My talk has a feminist twist, because I happen to believe that feminism is a thing and we have some progress to be made. It's an amazing, diverse group here, but we do have progress to be made. You can clap. Thanks. Cool. All right. So I'm going to start with a slide that I made myself. You guys, I'm an artist. I took graduate level art classes, so get ready to be wowed. I made it. Okay, so research shows that women apply for jobs if they meet 100% of the qualifications. Men, how much of the qualifications, what percentage do men have to have in order to apply for a job?
5.
I heard 20, I heard 5. It's actually 60%. So men apply for jobs if they meet 60% of the qualifications. My story is, in 2007, I cannonballed into a job as a 17th employee and first lawyer at Etsy. I was not 100% qualified for this unadvertised and undefined role. And actually, until my pitch, my CEO boss didn't even know that Etsy needed an in-house attorney. I keep getting louder. It's pretty cool. And you'll hear about the realities of helping an early-stage startup grow into a publicly traded company. This was me on a really exciting day. This is the day that Etsy went public. And it was at Times Square, and we had a whole craft fair. It was pretty cool. And then I'll talk about the top 5 lessons learned along the way, and why I left Etsy to join Vroom. So how did I get to Etsy? Well, when I was young, I was really interested in arts and crafts. I've been making all kinds of really ugly things since I was a wee lass. If you go to my parents' house in Rochester, New York, there's ugly crap that I have made all over the house, and it's really bad. But when I was 12, I took my first metalsmithing class, and I just fell in love with it. But true story, when you're taking metalsmithing classes, as you're hammering your metal, you hammer your fingers. And you sand your fingers, and there was blood and guts everywhere. And I realized that being an artist is really physically demanding. Despite the fact that I absolutely loved making metal, I just knew I couldn't dedicate my life to it. So I started to become curious about what aspects of jewelry could be protected. So business law classes and the LSAT follow, and all of a sudden I wound up somehow in law school. So in law school, I realized that it was going to come to an end one of these days, and I had absolutely no skills. And I was going to have to get a job in some point of this world, so I needed to come up with a way to find some skills. So that comes to lesson 1, which is create opportunities. I worked on an independent study, a plain English book tailored to artists. It was called Copyright for Artists. And I interviewed every single student in my metals class, and I used their feedback to make a skeleton of a book. And I graduated law school, I passed the New York State bar exam, but I couldn't land a job. So I moved back home to Rochester, New York to live with my parents, who are lovely people, but I was an out-of-work lawyer sleeping on my parents' sofa in Rochester, New York, but I was really an artist. So basically, I was like a sad 90s sitcom, but there was no Olsen twins there. So if there was an Olsen twin, maybe people would have watched the sad 90s sitcom, but it was bad. So I continued to work on my book, and eventually I did find a job at a law firm, and I did find an apartment, so I was doing a little bit better. And I was learning best practices, but I wasn't empowering small businesses, which is really what I set out to do when I got to law school. Also, I looked like this at work a lot. And to take this picture, it took a lot of effort back in like 2006. I had to like bring a camera to work and like set it up. I'm not really sure why I decided to take this picture, but now I like put it on my slide decks all the time, so good job, past Sarah, you figured it out. So when you're miserable at work, and has anyone ever looked like this at work? No, no one, just me. When you're miserable at work, what do you do to get out of that situation other than drink? Well, I realized that every week I decided that I was going to do two actionable things. I was going to do something actionable for my jewelry business, and I was going to do something actionable for my legal expertise. So on the jewelry side, I like literally collected all these necklaces that I was making, and I went door to door to boutiques, and I was like, "Hi, will you sell my jewelry, please?" And on the legal side, I pitched to article ideas to publications, I pitched to conferences, and I made all these presentations saying, like, I'm an expert in art law, you should have me speak. This Beat and Button article, which I'm pretty sure everybody, you have this magazine? Yeah, you've read it? Thank you. This was one of the very few times that I heard the word yes. Most of the times I heard no. Which brings me to lesson number 2, which is welcome no. I feel like a lot of people are like motivated and go out in the world and hear no a lot, but we don't really talk about it that often, but I do. But to be fair, I really haven't heard the word no as much as I do lately because I have a child. And he says no to me a lot, but he has a really great fashion sense. He put this together himself. So future lawyer right here, or future fashionista, I'm not really sure. So in 2006, I caught wind of Etsy, and I became absolutely obsessed with it. Clearly, I started selling my jewelry on Etsy, but then I started looking into the legal applications. And I saw some policies, and I grew a little concerned, so I reached out to the CEO and founder, and I was basically like, hey, here are some ideas. Do you want to talk on the phone? And he said, sure, here's my phone number. So after our call, a light bulb went off in my brain. I realized that Etsy didn't have an in-house attorney, and they sure needed one. So I immediately booked a JetBlue ticket from Rochester, New York to New York City, and I called him back and said, hey, I'm coming down for an interview. You need in-house counsel, and you need it to be me. I braced myself for a no, but I actually heard yes. He hired me on the spot. I proved through all of my credentials, all that work I had been doing on my book, researching his website and researching art law and all the publications. He felt pretty confident in hiring me, which was pretty cool. So people hear this story and they think it's really cool, and they say to me, wow, Sarah, you really leaned into that job at Etsy. I'm like, leaned in? I don't really think I leaned in. I think that's not quite extreme enough. I like to say I cannonballed into my job at Etsy. The swimming pool kind, not the kind that like destroys things. I think that Cannonball is a joyous act. It's not reckless, but it is designed to make waves, and it could absolutely annoy people on the sidelines when they get water in their face. So I bought malpractice insurance, I plugged my nose, I tucked my knees, and I got ready for the ride. So for those of you who work in-house at like a small startup, people have all these ideas of how glamorous it is and how they're like trampoline floors and sewing machines as far as the eye can see. Yes, Etsy had tons of sewing machines, but it wasn't glamorous at first. I didn't even have a computer to work on. I didn't have a desk. I had to buy a desk on Craigslist. This is me from one of the first days at Etsy. I was working on my own computer on the couch in the kitchen. So, all these companies, these startups, they're disrupting industries, and that's kind of scary. My role, I used to say, was a cross between a ping pong player and a firefighter, because issues would come to me and I would just have to like swat them away, and then issues would blaze up and I would have to extinguish them really fast. But in all seriousness, when you're the only attorney, you have to act as secretary or paralegal or janitor. But the way that I made sure that everyone always thought about legal is I made sure that I had candy on my desk. I would say to my coworkers, I've got your back and I have candy. And so people would come to me all the time because people say things when they're eating jelly beans. So if you ever want to get the truth out of someone, just be like, here's some jelly beans, and they'll tell you a lot of things. So I'm not going to pretend that I completed all these various tasks on my own. I reached out to a lot of really smart people to help me. And that brings me to lesson 3, which is use all the brains you have and all the brains that you can borrow. So to increase the brains I have and to find brains that I could borrow, I talked with pretty much anyone that would listen to me. Professor Askin was one of the ones that I would call every once in a while, and he was just really generous with his time, and I really want to thank everybody who, I'm pretty annoying, so like when I ask people things, but people have been really generous with their time, so that's really great. And I realized building relationships, it taught me that working hard really matters, but it matters just as much to be kind. And I think kindness is underestimated, especially in this legal industry. So my 4th lesson is to be kind. So before I go on to my 5th and final lesson, I do want to talk about increasing opportunities for women in tech and in the law. Now, study shows that actually the percentage of women in computing jobs is actually decreasing. In 1990, 35% of women held jobs in the computing industry, but in 2013, it was only 26%. So what can we do about this? There are a lot of things that we can do. At Etsy, to increase the candidate pool and its diversity, we offered some hacker school grants. Another thing that Etsy did is we had some special gender-neutral bathroom signs for inclusivity. And you can read them. It basically says, while the law requires gender binary signs on the doors, we believe that gender is not binary. Please use the restroom that feels most comfortable to you. So what about women in the law? Well, according to an American Bar Association study in 2011, 47.3% of JDs were awarded to women, so that's almost half. But we can't get complacent because women are more likely than men to opt out of the traditional law firm route. So for example, women make up 45% of summer associates, but women only make up 20% of partners. Why are women leaving, and what can we do about it? I don't know. I have no idea. But I think that conversations like this is a really good way to start this progress. I know there's no silver bullet solution, but maybe we need to disrupt the law firm industry, and maybe this group is just the group to do it. But one way that I know to promote equality is through language. For example, even as a legal department of one, my life has so many random letters and emails that come to me and faxes. Thanks, lawyers, thanks for the faxes. But sometimes a greeting contains a 4-letter word that is shocking to me. Brace yourself. The 4-letter word is sirs, as in dear sirs. Clearly, dear legal department, dear sirs, thanks. Now, listen, I get these dear sirs letters from all over the place. This one was from January 2016. It was from a giant law firm in the US. So there's no argument that there's some English translation language. So I'm just asking you guys, audit your communications to ensure that there's inclusive language in there, because it's really important to everybody. But additionally, we have to support each other. We need not just mentorship, but sponsorship. We need to sponsor people and push them to the top. We have to make sure we exude confidence and self-promote and own accomplishments. If you feel you're 60% qualified for a role or 20% qualified for a role, why not apply to it? But apply 100%. Really try to apply for something. And avoid imposter syndrome, and I'm sure a bunch of you here suffer from imposter syndrome. I sure do suffer from imposter syndrome. That's basically the feeling of phoniness in people who don't believe they're intelligent, capable, or creative despite of evidence of high achievement. I just say to imposter syndrome, go away. I'm not interested in you. Every time you start to doubt yourself, just realize that there are a lot more idiots out there than you. You're probably smarter than those other people. So just go away. Which brings me to my last lesson, which is say yes. Even when it's scary, and even when it takes you out of your comfort zone, say yes to opportunities when they come to you. And that's why I left Etsy, and that's why my career journey went from being miserable to Etsy, to the IPO, and I joined Vroom around a year ago. I'm their general counsel. Vroom is changing the way that people buy and sell cars. We sold $1 billion worth of cars last year. That's a lot of cars. That's a lot of money. And we're really making it a lot easier to buy and sell cars online, and we're making it more human as well and more transparent. So yeah, imposter syndrome was glaring at me, but I said yes to this incredible opportunity. So again, here are my lessons, and here's my contact information. Please let me know what actions you take for your own Cannonball, and if you ever doubt yourself, please remember me sitting on that Brooklyn, New York couch wondering what I got into. Thank you very much.
Okay, up next, for the second year in a row, Scott Allan. I pre-screened his presentation for awesomeness.
Thanks.
And it passed.
Oh, great. Thanks for raising expectations, Phil. I almost called you Jameson. My first mistake. Sorry about that. I'm really sorry about that. I'm so sorry. So I want to say thank you, of course, to Sarah for an amazing presentation. For Jameson, Phil, everybody, this is one of my favorite conferences I've ever been to in my career. Last year I had such a great time, so many great people, and this year again, last night, doing a clothing exchange with Dazza, and coming with 10 problems and solving 3 of them already. It's just a wonderful conference, and thanks guys for having me, and anything we can do to support it, I will do. It's a great group, and it's really a great time in legal tech. So anyways, this is my presentation, which when Jameson and I were talking about what I was going to present about, he said, well, why don't you talk about one of your projects? I said, actually, I would rather give me something difficult that would be useful for legal hackers. And he said, so how about addressing law firm culture? And so I said, sure, I can do a presentation on that. This was my working title for the presentation, which is Why People Hate Lawyers, That's You. And sort of thinking about law firm culture and law in society and how people generally feel about it. So they say if you want to give a good presentation, you have to know your audience. So this is sort of a yearly test that I do. I did this last year. The organization we're all here for today is called Legal Hackers, I believe. So I want to pretend that we're U.S. Customs and Immigration. And actually, everybody stand up. All right, now if you are asked to self-identify as either a lawyer or a hacker, you have to answer this question. You have 3 seconds to answer. I want all the hackers to put both hands in the air. Oh, that is so much better than last year. Thank you, hackers. Welcome. It's so great to see you. Please sit down. Lawyers, stay standing. Lawyers, stand. I still think there's too many lawyers, so next year we got to do better. So this is for the lawyers. These are the terms and conditions of my presentation. As soon as you accept them, you can sit down. And last year someone asked if it could be amended immediately, so I was like, can you amend that? No amendments allowed. All right, so I'm obviously from Canada, even though I'm wearing a Detroit Tiger baseball hat, which is a long, complicated story that I don't have time to get into. You may be able to have guessed that I'm from Canada by my strange sense of humor and the way that I pronounce some words. I'm just going to call out Eileen and Joe. Joanne, are you around somewhere? Yeah. So we've got a small contingent again here this year. Please say hi to them. And I have to leave, unfortunately, right after the presentation. But they are here and representing Toronto in Canada. All right, so on to the presentation, a little bit about me. These are some of the companies that I've been involved with in some capacity. So an internet service provider, largest domain name registrar in the world, security company, wireless company, some legal tech stuff as well. And I'm also just going to take a quick pause here to say I'm working with a company that sponsored the event today. It's a company called Wing. It's launching next week. I have 10 beta SIM cards, so if you're an American with a cell phone and want to help test the service, you can grab one of these from Phil or Jameson. Right. The other thing you need to know about me, there's this article when we founded Legal Hackers Toronto in Motherboard magazine, the device technology subject matter, and I'm not a lawyer. So they quoted this in the article, so it's going to be very obvious probably that I'm not a lawyer, but I'm going to talk about changing law firm culture. So I was reading a book, as I tend to do, and this is the autobiography, or the biography on an old entertainer called W.C. Fields. And I came across this word that I didn't know. I was unfamiliar with it, and it's the word pedophagy. And you can see here the New York Public Library did a whole session on, or some sort of program on it. And so I looked it up, as you would, a pedophager. And what is a pedophager? And it's an inferior legal practitioner, especially one who deals with petty cases or employs dubious practices. So I'd like to say congratulations to the legal industry for having their own special word for asshole. All right, so here, how are we going to change law firm culture? How are we going to make the world a better place? So in my businesses, when I want to change the outcome, I change the input. So law firms and their associated culture are filled with lawyers. And today, those lawyers have to go to law schools. So if we want to change law firm culture, we need to change what we teach in law school. And so if we're serious about changing, we should, and you're involved in any law schools, you probably went to one, they probably ask you for money. You should think about maybe guiding the curriculum and changing where you can, engaging with that system, because until we fix the institutions that create lawyers, the system is not going to change at all. So I think that's sort of one first thing that we could do to change the culture at law firms. The other thing we could do to change the culture at law firms is change the students. So right now, today, law schools attract certain students. Students with certain motivations, students from certain backgrounds. And I think we'd be well served to attract different students. Not saying anything against the current students, but maybe some students with different life experiences, different life motivations. So again, we're sort of changing the input to the law firm, diversifying it from what it's traditionally been. The third component that we can change in the input side is the law, the government. The laws that are written, the laws, how they're enforced, having reasonable, empathetic law enforcement as opposed to whatever you call what you guys do in the States with a lot of law enforcement that is, it seems to a Canadian unreasonable and certainly not very empathetic. So as lawyers, you can help change the law and make it better. And so we're changing the ecosystem that lawyers interoperate and then hopefully changing law firm culture. We could change law enforcement as well. I think I covered that kind of in my last slide, my comments in the last slide, but changing how policing is done is pretty important to changing how, because lawyers often have to respond to law enforcement and its related complications. Yes, and this is the slide about introducing more empathy. So what if we measured our success as lawyers not by billable hours or net contribution to the firm's profitability, but by how both sides rated the outcome of the deal? So what if that was the way we measured success in law firms? To me, that would be really interesting. It probably sounds really crazy to some lawyers and sounds really inspiring to others, I hope. And again, I'm just putting ideas out as to how we can change law firm culture, and changing the objectives and the motivations is definitely something that could help law firm culture. Right. So yeah, this is a slide about winning. So we want to, again, sort of create a situation where, as a lawyer, you have a fiduciary responsibility to represent your client. But you maybe have a societal responsibility to consider the opposing parties' needs and concerns, creating win-win situations. In my businesses, I end up dealing with a lot of lawyers, and sometimes great situations, sometimes challenging situations. I can tell you without a doubt that I have always been most successful when both sides are winning something in the resolution. If you want to go on forever, then if you want to spend a lot of money on litigation, then hold on to your position firmly. If you want to move on and do something more interesting than argue, consider the other side's position and create some sort of win-win situation. This slide is about how we bill for legal services. It says, "I hope this is the only bill you will receive today." It's a picture of Bill Murray, which you may have noticed is the theme of the presentation. Right, so how we bill. How do we bill for legal services today? We bill by the hour, we bill by the value of the contract. There's all sorts of different models. And in my legal technology companies, I talk to a lot of lawyers and law firms, and there's this reluctance to use technology almost in that they're afraid of what it's going to do to law and to how they make money. And, as a nerd, for me, I look at the technology and see enablement. I see a lawyer going from serving 50 clients a year to 500 by removing all the pedophagy and bureaucracy and all those things that keep you from helping more people. Access to justice is something that's really important, I think, to society, but certainly to me. And, using technology to increase access to justice is, for me, a good idea. So, in summary, we want to change law firm culture. I would say we should change the inputs, we should change the ecosystem, and change the incentives and rewards. And then, hopefully, we would end up in a better place. But if not, you can always just move to Canada and, where everything's, well, at least better. With that, I will say thank you very much. My email address is the letter S, @salin.com. If you want to get in touch, I'm happy to talk about anything, really. I'm super lonely, not. But again, I wish I could be staying longer, and I can't. So thank you for your time, and have a great conference.
Scott, I think your theme for last year was Donald Trump, wasn't it? Is this a prediction? Okay. Jameson, should we move straight into the panel and maybe split the two panels with the videos?
We can do that, of course.
We're right at the first panel time here, so.
Yeah, let's do that.
Okay, great. So up next we have a panel called Tech Policy, the General Counsel's Perspective, with Jameson moderating, and Adam Greenberg, Charlie Kwalwasser, Shin, and Sarah Feingold up on as the panelists. So come on up.
All right, so I think we're going to get started here. I have a fun announcement. So the panelists have graciously agreed to sing all of their responses in 4-part harmony. So we'll get out the barbershop quartet hats and get going. But this panel is called Tech Policy, the GC's Perspective. As I mentioned at the top of the conference, there are 3 general areas that legal hackers discuss during their events. One of those is legal technology. Second one is civic technology, and the third one is tech policy. Obviously, as general counsels, and I'll introduce them in just a second, as general counsels, they deal in many respects with certainly the first and the third, but also in some respects with the second, to the extent that they're interacting with government. So what we wanted to do is to take some time today to address some of those issues, ask some questions about how technology companies, and in particular their legal departments, engage on issues of technology policy. That's where new technologies, new business models, new service delivery mechanisms interact with the existing legal system that was maybe designed 10 years ago, 50 years ago, 100 years ago, or more. And raising challenges not only between the government and business, but also incumbent businesses that may have the ear of regulators and new startups and new business models. So anyway, with that, we'll introduce the panel. I'll give your names and your companies, and then what we'll do is we'll start with the first question. And the first question is going to be, what does your company do? What is your role within the company as general counsel? And then finally, what are some recent tech policy issues that you've addressed? So going down the line, we have Adam Greenberg from Warby Parker. We have Sarah Feingold, who you just met, from Vroom. Charlie Kwalwasser from Bark and Company, and finally Shin from Yext. So Adam, if you want to start.
Thank you for having me. My name is Adam Greenberg. I'm the lead counsel at Warby Parker. We are an eyewear retailer, both online and offline. Started as really a pure play e-commerce retailer, one of the first in the country to really figure out how to sell prescription glasses on the internet, and have since expanded a brick and mortar presence to over 50 stores. I'm responsible for all legal, policy, government affairs efforts at the company. Only recently did we start really getting involved in government relations and public policy work, and most of it's related to our recently introduced telemedicine product that allows certain people to download an app on their iPhone and take an eye test using only their phone and their computer, and on the back end, a doctor is reviewing all your data and issuing a new prescription if it's warranted. Telemedicine is legally kind of like the Wild West right now, and people are trying to figure out what to do with it, and there are many entrenched interests who want to put up barriers or restrict it completely. So a lot of our conversation on the government level, both federal and state, has been around how does this product work? What does it mean under existing law? How should law possibly be changed to expand access to telemedicine, and fending off efforts to restrict access to telemedicine?
Oh, that works a lot better. Hi, I'm Sarah Feingold. You might remember me from such talks as the Cannonball talk 5 minutes ago. I'm general counsel of Vroom, and Vroom is an online, mostly online, but we also have physical stores, car dealer. We buy and sell cars. So if you want to sell a car, you fill out some paperwork, or you fill out like this screen, and we will make you an offer. We will wire you the money. We will pick up your car. And then we take the cars, the cars that we think are worthy of being on our website, we clean them up. And if you want to buy a car, you fill out paperwork again, pay us some money, and we'll drop the car off at your door. So that's our business model. In 2016, as I mentioned, we sold over $1 billion worth of cars. As for public policy issues, there are a lot of state-by-state regulations for used car dealers, and so we're just navigating those waters. There's also regulations for titling, registration. We have people in our offices that they drive because they're in Texas. They drive to the DMV and they wait in line and file some title paperwork with the DMV. It's kind of ridiculous. So we're only on the beginning steps of trying to figure out how to work with the government, with state governments, and try to make this a little bit more easy for the regular human beings who don't want to hang out at the DMV their entire life, which I think is most of us. But at Etsy, I was involved in net neutrality and some internet sales tax issues and that sort of thing. So I had a little bit of experience on both.
Hi everyone, my name is Charlie Kwalwasser. I am the general counsel at a company called Bark. We're a dog happiness company. The way we make money is sell dog products, primarily. I'm general counsel, I'm the only lawyer there, so I do all the legal work and a lot of other things that get thrown my way. As far as public policy issues at Bark, it's not really something that is a major focus. We have more of, I would say, cause type focus around treatment of dogs and so forth. It's not so much a public policy thing as maybe like a social cause type of focus. Prior employers, not the previous one, but before that, when I worked in financial services, I spent a large amount of time on patent issues, both in Capitol Hill, and we also were active in the courts.
Hi, my name's Shin, and I'm with Yext. Yext is a software company, a SaaS company that is in an area that we've sort of dubbed digital knowledge management. We work with our software platform. Platform works with businesses of all sizes to help businesses keep their digital information up to date across all the different platforms that people consume data on. So whether it's Google Maps or Apple or Facebook, if you're a small restaurant that has weird holiday hours, or you might be Papa John's that has 200 different franchises, you could use our platform to sort of seamlessly keep all that information up to date and really manage all of your digital data. And so, it's interesting. So I joined the company about a year ago, and we actually listed on the NYSE, had our IPO this April. And so it's been kind of a hectic year. I'd say most of the year has been focused on just getting public, and so we probably haven't spent a ton of time focusing on really specific policy issues. I think also gladly, the nature of our business and the nature of the data that we deal with is far less sensitive than probably a lot of tech companies deal with, because we're working with companies on data they want actually facing public. And so a lot of the privacy concerns aren't there. Prior to Yext, I probably spent about 15 years in the ad tech business, and kind of glad to be out. But ad tech, from the early days, I'd say I was involved in, really a lot of tech issues, many surrounding privacy, I think, but sort of the early stages of the internet advertising industry, where I think there was this, real tension between consumer privacy and, commercial needs. So, I think I've got some good stories from that world.
Awesome.
Once we get into, yeah.
Cool, thanks. Well, the first question that I have, I'll start with you, Sarah, because I know that that Etsy had been somewhat involved in well, certainly in net neutrality, but also in SOPA PIPA. So Legal Hackers was born, I think, as Phil mentioned at the beginning, in 2011, 2012, during the Stop Online Piracy Act battle that was happening in 2011, 2012 in Washington, D.C. It really awoke, it seemed, the consciousness of tech companies in New York and Washington, and then also in San Francisco. And something happened that was really interesting, which is that many of these tech companies utilized both their public presence on the web and also their user bases to stage public protests, in a sense, blackouts of their websites, various petitions, or interacting with their user base in order to have them contact Congress in other ways. And so what I'm wondering is, as a general counsel or in a legal department in a technology company that's facing policy issues, what considerations go behind engaging in such public protests or advocacy campaigns, or not to?
So I think it's really important to, before you engage in any sort of public protest, to talk with your CEO and talk with your business folks and really have a big plan about this. When we were thinking about doing these sort of things at Etsy, we knew that we wanted to look at our community, we want to look at our business, we wanted to look to see if this even had an impact, this would have an impact on the cause. You don't want to, put your toe in the water on a ton of causes, because otherwise it might just be like, oh, this company is, of course, they're speaking out about a ton of different things. Like, this doesn't even make any sense. So we wanted to be really strategic about what we spoke out about. And when you're a company like Etsy, where you have user-generated content, where you have members that rely on you to make an income, you have to be really careful about what you do. So I think with SOPA and PIPA, Wikipedia, they went down for the entire day. And we had a conversation internally, like, should we go down for an entire day? And we're like, our members would be so mad at us. Like, that would really harm the community. So we wanted to make sure that whatever we did was respectful for the community and people who relied on the products and services for their income to pay bills, but at the same time voice that this was really important to us. So I think we had to come up with a solution in that sort of realm. But it takes a lot of conversations, and you want to make sure that everyone's on board, and that's something that you're willing to sign your name as a company and stand by for the long run.
Now, when, and by the way, if any of you have thoughts on any of these topics, feel free to jump in. You mentioned one example where it seemed to be the legal department going to the CEO and saying, hey, are you cool with this? How often does it happen the other way around, where the CEO is really passionate about an issue and goes to the legal department and says, I really want to dip my toe in the water on this, and then you need to walk them through why it is or isn't a good idea?
I guess it depends on the CEO, and it depends on what they're passionate about. Things come up all the time, and sometimes something will come up, and it's kind of like too late, something. But it all depends on the business. It depends on the CEO. It depends on your relationship with the CEO. But I think it's really important to try to look at what's coming down the pipeline and to make a plan so that you're not just trying to like fumble together something last minute that just doesn't make any sort of impact.
Sure. Does anyone else have any thoughts on this?
But yeah, before we engage in a policy initiative, we ask ourselves a few questions. One is, what kind of an effort is this going to take? How much time and away from operating the business is this going to take? Two, if successful, what's the impact on our community? So on the business, on our employees, or on our customers? And three, what can Warby Parker's voice really do here? How could we be impactful, even if we engaged in all these efforts, spoke to all these people, wrote letters, posted stuff online, talked to legislators? Do we really think that we can have an impact on this issue? So those are the kind of questions we kick around. We're asked pretty regularly to sign our names to amicus briefs, to letters to the president, letters to the senators. Those are pretty easy tasks as long as you agree with the policy perspective. So if it's something that we agree with, we're often saying yes to those kinds of things, but major initiatives where you're leveraging the voice of your customers, those are much more difficult. You have to be very careful and sensitive to how you're engaging your customers. Our customers don't make money off of our business, but we don't want to take advantage of the fact that we have their email address or the fact that they love our company. If it's something that we think will benefit them, we will engage them. And we've really only done this rarely. The one time about a year ago, so we've been advocating for a couple years at the FTC to pass consumer-friendly regulations, amendments to what's called the eyeglass rule. Eyeglass rule is a federal regulation at the FTC that says if you're an optometrist and you give someone an eye exam and they pay for that eye exam, you need to automatically deliver their prescription to them. You can't condition handing over the prescription on purchasing a pair of glasses from your glasses store. And we're trying to make just common sense amendments, especially amendments that will help people buy eyewear products on the internet. So what we did was we engaged some of our customers and said, if this is an area that's important to you or you're passionate about, feel free to reach out to the FTC. Here's where you could file a public comment. Here's a template that could help you out with some language that might be helpful for you. But other than that, we've really been reluctant to ask our customers to help us out in those kind of initiatives.
I'd say, it really depends on the type of issue you're talking about. I think, as was discussed here, if it's sort of more a social-oriented issue, then I think it's often easy. We signed on to as amicus for the travel ban, for example, that came out. And that was one where there was an easy consensus among the executive team, really no discussion, and a very strong conviction that this is the right thing to do, both from a social public policy perspective, as well as what's good for the business, what's good for the company, given how many foreign workers we employ. And so that's pretty straightforward. I think sometimes you get into a issue that has a significant impact on how you do your business and could be very core to how you do your business. And I think that really depends on, again, what the type of issue is, but also how much in front of the issue you want to be and how visible you want to be. I think, for example, in ad tech going back a few years, I think there was always a lot of attention, again, on data privacy and user privacy. And my previous company was Millennial Media, which was one of the early mobile ad tech companies. And we also knew on any given issue that Google and Apple will probably be out there sort of fighting the fight too. So, I think you can sort of draft behind some of their efforts and know that they're going to probably address the issues in a way that's going to be favorable to you. And, frankly, I don't know that you want to be, if you're not quite as out there and well known as them, I don't know that you want to sort of raise your hand and be in a room with an FTC, official telling them about, sort of your profiling plans that you have and what you might do or what you can do. And so I think at times like that, it's sort of, strategically best to sort of sit back and see how an issue plays out.
Sure.
I agree with everything that was said. Just the only thing I would add is sometimes it's important to be aware of what might be expected from your company by the public instead of thinking completely about kind of your view internally. One example that comes to mind is I think it was maybe like almost a year ago, there was a taxi driver strike at the airport. I think it was because of immigration ban. And Uber continued to go there to pick up passengers, and it became like a big controversy. So, sometimes you need to be really thoughtful, even if you're not even participating in something.
Sure. And actually, Charlie, I'd like to stay with you. You mentioned your work in financial services before. And many of your startups are international in nature, if not entirely global. The internet itself is global. So my question is about policy management. And we talk about one particular law, right, or two laws, SOPA-PIPA, for example, or the eyeglass rule, or something like that. Very targeted. You go down, take care of it. But the financial service industry is heavily regulated. It's global. You have to deal with different jurisdictions. As a general counsel, how do you manage all of the various battles that you have at one given time?
So you're just asking generally, not just domestic versus. You have to prioritize. I think you have to be very in tune with management in your company and what's important to them. Someone has been using kind of like a recurring phrase with me recently that I think is like a really helpful thing to think about. It's about not making molehills into mountains, but making mountains into molehills. So you really need to focus on what is something that could be of significance, and then those things that are not, to make them just something that aren't going to be a problem. Time management just kind of takes over. And use resources that you have, especially if they're low cost. No real kind of special formulas.
Got it. Adam, I have a question for you, which is, we talked about I think it's well known in the public, the way that Uber approached regulation, or at least local regulation, which is go in, build a user base, make them really happy, and then approach the regulator and say, listen, I got this user base. They don't like the taxi cab industry. They don't like what they're paying. Now you should change. They felt like they had leverage at that point. Obviously, you need to deal with issues at the state level and then also at the federal level. Do you think that approach has evolved over time? And what do you think the best way is, or what's Warby Parker's perspective on how best to engage on those issues?
Yeah, we're pretty new to government affairs, and we're still trying to figure out what our philosophy is. But when Warby Parker entered the optical industry about 7.5 years ago, we certainly had a different business model than most eyewear sales, but we weren't facing any regulations or existing statutes that posed existential threats to us or would have threatened to shut down the business. We operated within the regulatory framework. Granted, there are these regulations that, and it might not be apparent on its face, but the act of selling a pair of prescription glasses is a highly regulated activity. About half the states license the activity, and there are a lot of regulations about what someone who holds a license can or cannot do with respect to giving you a pair of prescription lenses. So we've operated within that framework. There are ambiguities. The laws clearly don't, because they were written in the 50s and 60s, don't speak to selling glasses online. It's not always clear where we should land on a particular issue, and we assess that one by one. But we when it comes to telemedicine, which is really now how we're engaging with existing regulators and talking to legislators, we've taken the approach that we want to educate folks as early on as possible. We know that there is a lot of misinformation being told to these people, so we realize that we decided we're going to commit resources and time to flying to St. Paul, Minnesota, and spending a couple days meeting with senators and Congress members in the state to educate them on what ocular telemedicine is, what our product is, how it works, how it is legal under existing statute, and why the state should not be considering more restrictive legislation. And we found that once we get in the room with the people that are making policy, our argument prevails. It's just getting in that room. So, kind of a necessary evil is hiring a local lobbyist, and a lot of my time over the course of the past 6 months has been quarterbacking and managing a network of state lobbyists who arrange the meetings, have the relationships with the policymakers, and then traveling across the country and taking meetings and introducing people to Warby Parker and to the technology if they're not aware. So we found that approach to be working for us. We don't necessarily agree with the approach to just operate and launch and then ask for forgiveness later. We wanted to make sure we were introducing a product to our customers that in a few months down the road we wouldn't have to take away from them. We want to make sure we're operating in an environment where we can continue operating, continue improving upon the product, and offering that experience to our customers.
Got it. How about the rest of you? Forgiveness or permission?
I certainly wouldn't advocate Uber's approach to just about anything. But I think that sometimes sort of a forgiveness approach is probably not a bad way to go when you're dealing with an area that probably there's not a lot of guidance. I think somebody mentioned that you're often dealing with sort of old laws that don't necessarily apply to new practices. And certainly, when we were sort of in the early stages of mobile advertising, and I think people were just starting to get used to the idea that iPhones or Android devices could actually track where you're going with GPS devices. And I think in the early stages there wasn't a whole lot out there that really provided much guidance on what was right and wrong. So I think you really have no choice but to sort of go out, do what you're doing, and hope that you're not crossing many lines. I think one thing that really helps in that regard eventually is sort of consumer and regulator education. I think that and sometimes if it's a new industry, it's just a question of time before people can actually get a handle on what's going on. It's funny because people were all freaked out. When I first joined Millennial, it was right on the heels of a Wall Street Journal article that was, really creepy, and your apps are following you, and this was like the first generation or second generation of iPhones. And and then you look at, Facebook and all the other social media, and people are checking in and telling the entire world, not just, where you are, but so many details about your personal life that you wonder, like, how is, there's such a disconnect. And so sometimes it takes regulation a while to sort of catch up to some of the technology and, certainly the consumer practices. And so I think there are times where you would just really have to go out there and kind of, go out on a limb or sort of take a leap of faith that what you're doing is okay, but it's going to, eventually be seen as okay.
Sure. Charlie, do you have anything to add?
I think it depends on the circumstances. I mean, if you have no business, if you don't take the risk, then you take the risk.
Sure. You've mentioned, Charlie mentioned before, Ho mentioned before as well, certainly there are core policy issues, things like intellectual property or net neutrality, things like that, that come up, tax. But there are also many social issues where tech companies have been getting more and more involved, which has both an external component, stating your values externally, but also an internal component, which is how you treat your own people. In the immigration debate, for example, a lot of it was about their own employees who were coming, or university graduate students who were coming to study STEM courses, things like that. So what I'm interested to know is, from your role as a general counsel, what's your role, first of all, in the external messaging, getting that message out there with any potential legal risks or strategy risks, but then also working with the people team internally? What role does a general counsel play to make sure you're, first of all, compliant with the law, but at the same time espousing your values, demonstrating them? So you can start with Ho, maybe, and work our way down.
Sure. I'd say, taking my job right now, I'd say I'm, legal is very much involved in both those things. I think, anything that's sort of external facing now, just as a byproduct of being a public company, I think everything has to be sort of reviewed by legal. And so we work hand in hand with, the marketing team, the comms team, and essentially review everything. Internally as well, we work very closely with HR. Obviously, there's a compliance aspect to it, but kind of feel like, just the way our company is operated, I think we're all we view each departments as, we're colleagues working together. So I think, no one would really think to do something without sort of collaborating on it. So I think, internal messaging probably falls under that. And I think, it's funny because I feel like we happen to work at a company that, at least the leadership and probably the broader group of employees are somewhat like-minded, and there are probably some issues, like you talked about, social issues that, are sometimes present some, interesting challenges. And I think as the GC, sometimes, I think first you have to look at it whether there are any legal implications, but then I think we also look at it at issues, in terms of what's the right thing to do. I think recently we had a situation, for example, LGBTQ is an issue that's probably evolved over the years as well. I think we as a company have determined that the right thing to do is to be inclusive and to not be, shy about being inclusive. And, we've done things like, a couple weeks ago we did, maybe longer than that, during Pride Week, we, showed our support for it. I think Google Business was launching a new feature that allowed businesses to say whether they're LGBTQ friendly or not. And we, made that, for our customers, we made that functionality available as well. And, we had a client or a potential client, I think, who may have seen some of the publicity around that. And, they said they weren't going to work with us. And, that was, an interesting situation. And, the company pretty much said their religious beliefs prevented them from working with us, from working with a company that was, so openly supportive of LGBTQ. So, in that situation, again, it was relatively easy. There wasn't much to deal with from a legal perspective. I think as a company, there was no sort of disagreement whether we were taking the right position or not. Everybody felt like, okay, we're going to lose some customers, but we felt this is the right thing to do.
Sure.
And that I think that has also evolved. When I was in ad tech, 10 years ago, that there you saw situations come up as well where you have a publisher network with some publishers that are targeted to gay audiences, and sometimes you'd get an advertiser who would find out that they were run on these sites, and you'd have some real issues to deal with, some of it contractual, and I think you'd have to deal with the legal issues first, and then think about, as a company, sort of what sort of policy do you want to stand behind.
Sure, absolutely. Anyone else? I'm really interested in the people side of the internal side of things, and actually, Sarah, you at Etsy, you would have to deal with not only your own internal people, but also your customer base. Was there ever a situation where you felt a tension between the things you wanted to accomplish socially, culturally, and then what your user base wanted?
Well, I think when you have a large user base, a lot of people have different opinions on all sorts of matters. And so I think whenever we at Etsy would go out and be really strong for or against a certain cause, we would take into consideration what our members might say. But at the same time, we wanted to make sure that we didn't let the vocal minority dictate what we did, because I think if you are just waiting for every single person to give you the big thumbs up, like you're doing a great job, then you're never going to get that. So you really have to just take appropriate risks and just be prepared to either lose some business, which can happen and will happen, and then just be prepared with responses. So either responses to your customers, responses in press, and just make sure that you talk these things through and really set expectations for your leadership that, hey, listen, we think that this is important, you think this is important, however, we're going to get some pushback, and we're going to anticipate the pushback, and we're going to be prepared.
So, there's one of the things that's happened recently, I think for our international audience members out here, this may be interesting to you, but of recent vintage, there are several corporate structures, but also certifications that companies can obtain or can register as, that allow them to not necessarily put the profit motive to the side, but put forward their own particular values and let their values lead rather than the profit motive if there's ever a tension between those. And those are the B Corp on the one hand, which is a certification that you can obtain, and then also the Public Benefit Corporation, which is available in a number of states that allows you to register as a company that essentially puts its values first in some situations. Two of the companies, I think at least two of the companies on the panel have certified themselves as B Corps. So I'm interested to know from X company, I suppose, Etsy, and sorry about that. So I'm interested to know what led that decision, and what was your role in that process. Maybe I'll start with Adam.
Sure. Warby Parker is a certified B Corp. Have a very close affiliation with the nonprofit B Lab that administers the certification. Warby was a B Corp way before I ever joined the company, so I wasn't involved in that decision-making process. Essentially, what we say, what the B Corp status means is that you consider more stakeholders than just shareholder value. Not in your corporate documentation, not in kind of your legal structure, but as a company philosophy, your mission is to think about helping other communities, other stakeholders as well, around the environment, around supply chain ethics, workers' rights. So that is core to the company's value system. The kind of what Warby Parker is most known for on the social responsibility, social innovation front is our buy a pair, give a pair program. For every pair of glasses we sell, we distribute a pair to someone in need somewhere around the world. And in terms of policy making and government affairs, there hasn't been much overlap between our buy a pair, give a pair program and our kind of government affairs efforts until recently, when we partnered with the City of New York, with Mayor de Blasio, to commit to providing free glasses to any community school child in New York City who needs one. We found that there are a lot of school children, the public school children in New York, who need glasses and don't know that they need glasses, and it really transforms their lives and their performance in school and their happiness in school once they realize that and they get their first pair of glasses on their face. So last school year, I believe we distributed 15 or 20,000 pairs of glasses to community school students, and next year we will plan on distributing even more. In talking about that, especially with New York policymakers, has been really helpful, and it brings, generates interest for people to get to the table and talk to us about that and other policy issues. But yeah, that philosophy, that buy a pair, give a pair program, has been core to the company since its founding over 7 years ago.
That's amazing. Way to go. I just felt very emotional thinking about like a kid and who couldn't see the board and now has a really cool pair of Warby Parker glasses like down the street. Like sometimes you hear about these, buy one, someone else gets one, and it's far removed from you. But as a New Yorker, that's amazing. Thanks for doing that. I didn't know that it was so close to home. I don't remember the question.
B Corps.
I was too busy listening to Adam. Something about B Corp certified. Etsy is again, I haven't worked there for over a year, we were certified and maybe are right now with B Labs, and it was a decision because it felt really core to Etsy's values, and to be certified, it was a big pain in the butt. So we had to do like happiness surveys. We had to look at our metrics for different employee types. We weighed our trash. Like every day we would weigh our trash and see what was getting composted. And we looked at our water usage and our electric. It was no joke.
Don't you have to measure the number of miles employees travel?
Yeah. We had to do that. It was just, and then you're just waiting for your score to come in, and you had to get a certain score, or else you wouldn't meet expectations, and we did. And then the next year we did it even better, and we were really proud of ourselves. But it's a big pain in the butt to take on that, but we thought at the time, and I don't work there anymore, that it was worth it. And we thought that it was really valuable to our employees, for our culture, for what we stood for as a company.
Awesome. So before we go into questions, I just want to wrap up with another core thing for legal hackers, which is the practice of law itself and innovation in the practice of law itself. So maybe I'll start with you, Charlie. What I'm interested to know is you've been in everywhere from a large company, a large, heavily regulated company, to a mid-sized startup, to a brand new startup where you're serving as general counsel. How have you seen the practice of law change? And how are you integrating technology or leveraging tools from, say, the tech community in order to be more efficient, to get more done when you have fewer resources, say, in a startup?
Okay. So I've only been a lawyer for 16 years. So the entirety of my career, I've had the internet. I have no lawyers that started without the internet, so they have really good examples. So Google has changed my life as a lawyer, especially in-house. It's amazing what you can do with Google. When I used to be at a law firm, I remember I worked on a case and we were doing document review, and I was actually reviewing hand-drafted red line copies of merger agreements. So one thing that's definitely changed my life is I don't need to use outside counsel to draft documents. I could do it myself because I have the ability to redline documents myself. Again, these are things I've always had, but I imagine if I didn't, it would have been a big pain in the butt. How else has it changed my life? I think there's a lot more collaborative tools that you can do that are cloud-based now. So that's super, super helpful and efficient when working with outside counsel or not needing to work with them at all. DocuSign is fantastic. I love DocuSign. Don't have to sign things by hand and scan them in constantly. What else? I'm sure there's more.
Do you find that you're relying, well, you mentioned contract drafting, relying less on outside counsel. Do you find that across the board you're using outside counsel for more targeted purposes or more limited circumstances?
So, everyone has a different philosophy on this. I tend to be a cheap person, so I don't use outside counsel much generally. But I would say when I use them, it's primarily for something that I feel like I just cannot do by myself, either because I don't know it or I don't have time to do it. Otherwise, I try to do it myself, unless someone wants to use outside counsel. The biggest examples would be if we're in litigation, I'm always using outside counsel, like patent and trademark applications. We don't have internal people doing those. That's probably the biggest. I mean, if we do like a financing, whether it be equity or debt, we're going to use outside counsel. But pretty light usage if required.
Gotcha. Anyone else? How technology has changed your practice?
So I'm probably the oldest one up here. So I started practicing about 25 years ago, pre-email. So early on in my career, I was a litigator. So sadly, I spent many hours in conference rooms full of literally piles and piles of documents. So that has changed significantly. I think the one biggest aspect of it is it's really made the world smaller, and so I do deals now, or we can do a merger where I'm sitting in Washington D.C., my lawyer's in L.A., and we're looking at where the target company is in Boston, and or take that even further, and you might be looking at an international company. And so I think the means of communication, the ease with which you can send documents back and forth, and negotiate the documents is much easier. Doing even some of the more mundane stuff like board consents and board books and things like that become much easier with technology and DocuSign and things like that. So it's all I think for the most part it's all very good. I think it also I've noticed an uptick in typos and mistakes coming from outside counsel that you're paying $1,000 an hour for. And so that gets a little bit annoying because I think that is too much of a reliance on spell check and document, word processing tools. But it's changed significantly since when I started out.
Gotcha. Sarah, how about at Vroom?
+1 for Google, +1 for DocuSign. So I started my career at Etsy in 2007, and when I moved to New York, I was just looking for people who were at like similar small startups and were in their legal team, and there weren't that many. And now I just feel like everyone I meet is a general counsel of a startup, which is so awesome. And I think that the internet is because of all of this. So it's making the practice of law a little bit better for me because I have other friends that I can call up and say, hey, you're in a very similar situation. Can we talk about something? I'm also on some really amazing mailing lists where we trade information or suggestions or even documents like, I'm writing this policy. Does anyone have any suggestions? And people are really generous. So I think with the internet and more lawyers in companies, it's been great for me.
Awesome. Adam?
Yeah, I might be maybe practicing law the fewest amount of years here. I don't know, but all those tools are great. But I still think there is work to be done. A lot of what we do is still manual and tedious. For example, I still need to read every word of the contract. I mean, unless you make a concerted decision not to read certain contracts, but there are tools out there that use advanced technologies to scan a document and maybe let you know what terms there are in there that are unfavorable or unacceptable to your position. But we haven't come across anything that is worth really exploring or is affordable. So it's still a lot. There are more tools and more collaboration tools that lawyers could adopt, especially at law firms. And at law firms, I'm still getting long memos and still downloading Word documents and then reattaching them and downloading PDFs and getting faxes like Sarah mentioned. If we could figure out a way to get law firms to join in using collaborative tools like Google Docs, for example, is a big one. I don't think at Warby, I manage several law firms, maybe a network of 15 to 20 law firms. We've taken the approach that we want to use experts in the subject matter where we need help, even if it means signing on many law firms as opposed to one law firm who could do everything, moderately well, which it gives me kind of an extra administrative headache, but I think is best for the business when you get the best advice. But I don't know of any law firm that we work with that uses Google Docs, which is really helpful when you have to be the middle person between the law firm and the business folks and reinterpret those conversations for the other side. If we could all kind of get in the same room and talk about stuff, it would be really helpful for the in-house counsels in the room.
We were recently doing a round of funding, and I was using Google Docs for some of our disclosure schedules, and I think outside counsel was like, "What is going on here?" And they had to get Gmail accounts so that they could open them up. But it made it so much easier for me to collaborate with all the stakeholders in the company, and then eventually it went back to Word. But it was great for me for the time being. But they sent it to me in Word, and I just took it, cut, paste, Google Docs to get things done.
Going to admit that I do the opposite. Whenever someone sends me as a Google Doc, I turn it into Word.
So I'll do one better. We still spend.
Turn it into a fax.
No, we
You handwrite it.
We spent many all-nighters at the financial printer doing, pen markups of printer-proof documents, and I think there are programs like Workiva who are doing great jobs with S1s, but I think people of my generation will refuse to ever use those because it's not how we've done things. And so that's one thing that I have to confess that I'm probably in the dark ages about.
Law firms will still refuse to use Workiva or similar for that part. Yeah.
Sure. Great. Well, first I want to thank the panel, and then we'll go into questions. So thank you very much. We have a few minutes for questions, so if anyone wants to ask a question, we
have to use the mic.
lavalier.
Here it is.
Yeah. You have to stand. Yeah. There you go.
Thank you guys. That was a great panel and very interesting. Just picking up on the last point about the collaborative work tools and things in Google Docs, one of the things I'm always super curious about, and I'd love to hear your view, particularly like Allan, you were saying the way you've kind of parceled out your legal work by expertise. So I used to be an M&A practitioner, right? So I used to do that internally to all the specialist groups. And it would always come back through you, and you were running the document, right? And there's definitely a lot of inefficiencies there from a process perspective. But the one thing it always did is it helped. There was a quarterback who was getting all that specialist information, who had visibility across a complicated deal and would know, oh, this environmental lawyer just said this thing which is relevant over here that they would have no idea about, but I now know this. And so I'm always really curious how people who take this approach, and you certainly gain inefficiencies from it, have you encountered kind of problems where you really, there are some benefits to those inefficiencies of having these process inefficiencies, funneling things through like very narrow bottlenecks. Have you encountered any of those? And if so, like what do you, is it worth it from a trade-offs perspective? I'm just very curious.
Yeah, I mean, there are difficulties being the quarterback, being the point person. What I've tried not to do, we work with a workforce at Warby Parker that really don't have careers that have put them in front of very many lawyers. So long contracts, legalese could be intimidating to them, and I don't want to put them in the position of having to deal with that stuff. So what I've tried to do is not take the approach where I just forward on advice from counsel. And what we're working on most of the time are not big deals. So it's not really one merger agreement that's getting marked up a million times. It's asking, we're thinking about this kind of advertising, or we're thinking about doing this sort of activity in our store. Is that okay? Like, is that a good idea or a bad idea, right? And a lot of time it'll generate a lot of back and forth conversation with the specialist outside counsel we're dealing with. And I don't want to have to put my colleagues in a position of interpreting some arcane law or a long memo that a law firm writes me. So what I try to either do, and it adds more time to my work, but also ultimately ends up being the most efficient approach, is either getting everyone on the phone and being on the phone with them. And so instead of trading off really long emails, it's probably also more efficient from a cost perspective for us to just get everyone on a 15-minute call rather than exchanging emails over the course of 3 days. But also, take it when a call's not possible and I want it to be on paper or on email, take what the attorney says to me, try to distill it in kind of business, plain English terms, an actionable recommendation for the business person, which leaves us running around in circles, talking to a bunch of people and trying to distill information from both sides, inputs from both sides, into something that'll make sense for the lawyer on one side and something that'll make sense for the business person on the other side. It adds a lot of juggling conversations for us, but I think it's most efficient ultimately not to just throw your colleagues in the deep end and say, here, go figure it out with this lawyer who might not be speaking the same language as you, figuratively.
I actually have a question. So staying on the topic of technological solutions, improving the practice of law, and one of the things you had mentioned was something like OCR or being able to read documents electronically and picking out terms. But what are the other areas where you see technology lacking that you wish would improve or could improve to help your practice as a general counsel? I'm looking for business ideas, basically.
I don't know. It's up to you to start your business, my friend.
He's on my team, so I wouldn't encourage that.
If you can figure this out, it'd be fantastic. So, bridging the gap between something that's truly easy to read in plain English and something that someone will read, and satisfying regulatory requirements, because they're completely, especially in financial services. I mean, I got something in the mail recently because I think one of my credit cards, they changed the terms of the agreement. Literally all they changed was, I think they instituted a late payment fee. I had like 10 pages in my envelope. It said the same thing 50 times. There was like all these documents saying what it was saying. And I'll give you another example that's completely ridiculous. I'm kind of venting now. I have a mortgage with Citi. I called them because I got like an escrow statement. I didn't really understand it. By the way, I have like a CFA and I've been a lawyer for 16 years and I don't understand the escrow statements that they sent me, but that's another issue. So they sent it to me, and the first thing they say on the call is, this is an attempt to collect a debt. I'm like, but I don't owe you any money. And they're like, yeah, we know, but we have to state that. New York State requires us to say that. So these are just examples about if you can figure out a way to kind of bridge regulatory satisfaction with common sense, you'd be a millionaire, a billionaire, 100-billionaire, trillionaire.
Awesome. Terrence, and I think that's gonna have to be the last question, unfortunately. Sorry about that.
Sorry.
Yeah.
Thank you very much.
Right up here. Yeah, because otherwise you're gonna get feedback.
Sorry about that. So thank you very much for the talk. It's very insightful, and I'm very curious about the policy advocacy problem, that how you get the permissions or forgiveness sometime, maybe in some occasions. I understand the technology policy often involves a lot of online transactions and shared economy, and then the most real part from the government is about the enforcement, like particularly in the time of fraud. So how would you convince the government that to take a less restrictive approach, particularly that enforcement is not easy in this type of business?
That enforcement would be difficult?
Yeah, the enforcement will be very difficult. How will you convince them mitigate their concerns about over the enforcement issues?
Yeah, so our policy issues, I guess we've had kind of different conversations with regulators and policymakers, not so much from a standpoint where we try to convince them not to enforce something or that enforcement will be difficult. Mostly our conversations are, please don't pass this law. This law would be a really bad idea. And I'm pretty new to this, but what different arguments play with different people depending on their where they land on the political spectrum. So a lot of it is, and a lot of my job lately has been more of PR than it has been of law. When you get into a room with a policymaker, telling the right story that will make that person interested and kind of, especially state legislators, they have so much going on. There are hundreds and hundreds, if not thousands, of bills introduced each session, and everyone's knocking on their door, and you get like a 15-minute window to get in there and tell them what you want to tell them, and it needs to be concise, and it needs to be something that it's going to be impactful for them. So it's really intellectually stimulating activity, trying to craft that message for each individual person based on what the local expert is telling me that person cares about. So very heavy on a lot of time spent on messaging and understanding who you're talking to and what makes that person tick.
Great. Thank you all very much for joining. And on to the next panel, blockchain. Thank you very much. Awesome.
So we're going to be talking about blockchain and reviewing what happened in the last year, and also thinking about what might happen in the future. I'm going to introduce our panelists, who it's an honor to share a panel with. We have Reuben Bramanathan, who's product counsel at Coinbase. Reuben wrote and lectured the world's first postgraduate course on the regulation of digital currency and co-authored the blockchain token securities law framework. He has been advising clients in the blockchain space since 2014 and regularly delivers presentations on the regulatory and policy challenges of blockchain technology. We have Daniel Dazza Greenwood, and he is the founder of Civics, a boutique provider of professional consultancy services for digital identity, automated transactions, data management, and technology strategy. Dazza is also a visiting scientist at MIT, where he is creating the field of computational law and building out MIT.edu blockchain research portfolio. As an attorney, Dazza served as both in-house and special counsel for technology law, representing corporations and governments as an intellectual property litigation expert. And Dazza has testified before the U.S. House, U.S. Senate, and other legislatures on electronic transactions law, and consults extensively the public sector, including to NASA as online identity expert, GSA as multilateral rules drafting expert, Homeland Security as a multi-state federated identity expert, and the UK Cabinet Office on population scale identity federation rules, and many other public and private sector organizations and global NGOs. Pat Berarducci, who's on the end there, does law and software at Consensys, a growing venture production studio with over 300 employees globally. And Consensys works directly with startups, large corporations, and nation states to deliver blockchain solutions based on both public and private Ethereum implementations. Prior to joining Consensys, Pat majored in computer science, researched and published on artificial intelligence, practiced law for 7 years at Sullivan and Cromwell, and was a co-founder and software architect at a health tech startup. Houman Shadab is a co-founder of Clause and professor of law at New York Law School and a director of the open source contract tech consortium, the Accord Project. He is a prolific and influential expert in financial law and regulation whose research focuses on financial technology and blockchains. Professor Shadab also often advises corporations, financial institutions, and startups, and has testified before the federal government several times, including before the Commodity Futures Trading Commission on Bitcoin derivatives. Nina Kilbride is head of legal engineering at Monax Industries, a software company developing ecosystem software from a toolkit of blockchain technology, smart contracts, and legal processes. Before becoming a software developer, Ms. Kilbride spent 18 years as commercial litigator in North Carolina, South Carolina, and Georgia. She has a JD from Wake Forest University School of Law and a BA for Southwestern University. Her blog on smart contracts and other projects are collected at ninakilbride.com. I'm Noah Thorp, your moderator. I'm a co-organizer of the SF Legal Hackers Group, which we just recently restarted with Tony Lai, who's here. And I'm also the founder and CEO of Comakery, where we help networks of collaborators build products together and award tokens for code design and other contributions. Prior to CoMakery, I co-founded Citizen Code, where I led blockchain innovation prototyping studio and implemented responsive organizational structures like Holacracy. Before that, I was the VP of engineering for NASDAQ Private Market and also for SharesPost. Before we get started, I just want to do a quick audience poll, which is who here has owned a cryptocurrency like Bitcoin, Ether, Ripple, or Litecoin without disclosing which one? Okay, it's interesting. I won't ask you the ICO question. Who's concerned about a potential ICO bubble? Okay, it's interesting. And who here is working on a project that incorporates a blockchain? Okay, cool. All right, great. So we're going to jump right into the panel questions, and I'm going to start with something a little more open-ended, which is what are you doing right now with blockchains in the legal space? And maybe we'll start with Dazza.
Great, thank you. And I agree, it's an honor to be on this panel. Some of these people I've wanted to meet for a while. So this has been a big year, I think, for blockchain, and I think it's evidenced by what I've been doing lately is stuff I couldn't have even done at the end of Legal Hacker Summit last year. Yeah. So in Massachusetts Legal Hackers, over the last couple of plus months, we've had a collaboration with Toronto Legal Hackers to test the legal sufficiency of digital signatures that are generated from key pairs and blockchain addresses. And it was pretty hard, but at least it was doable to be able to reuse the key pair to digitally sign data like a PDF or JSON data. The frameworks and just the design patterns and just enough people that knew what that was all about were not readily available. And I don't think I would have had the idea to do it at the end of last time either. So we did that, and we're going to do a mock trial in the next month or so, which we've been practicing. I think the major thing, though, is what I talked about last year was the need for using a blockchain for the law itself, for statutes, for regs, for legal documents. I called it lawchain.org. Now, thanks to a couple of legal hackers, I've been introduced to Integra Ledger, and it's a David Fisher's thing. And they're actually going to be using Hyperledger for a legal industry blockchain, a generic one, to identify entities and documents, matters, very infrastructure kind of stuff that we could build upon in a reasonable way, like other sectors that have successfully transitioned to a digital footing. So I feel like things are really coming together in a great way, and in my case, MIT's great, and startups are great, and commercial clients and government's great, but there's no single place that I've learned more, been able to collaborate or innovate more than through legal hackers on blockchain, especially as applied to law. So that's the current status and seems to be getting better.
Cool.
So I'm Nina Kilbride. I'm head of legal engineering at Monax, and for the past year, since we were here last year, we've been working on executing those things that are going to be necessary in order to bring all these long tail pie in the sky blockchain dream use cases to life, which is really boring. It's like being plumbers maybe, except for if you really like that thing, which I do. So, first we're dealing with things like financial market infrastructure. What does it really take to make a viable financial market infrastructure that complies with what we consider now as lawyers existing best practices, but then takes into account and begins to bring to effect the potential that technology has to do with that. So what does it take to do a issuing and paying agent that complies with global specifications? Then how do you quantify spread and mitigate risk? For example, reinsurance along several layers of risk. Once you finish that, we're ready to start doing the exciting long tail use cases, and that's basically where we are now. We've kind of got a lot of the plumbing finished.
Excellent.
So I'm going to be a little controversial and talk about ICOs real quickly. Even though I raised my hand to say, yes, I think we're at risk of an ICO bubble, I think what's super interesting is that it's the first real-world use case for smart contracts. So putting aside the regulatory issues, of which there are many, it's actually the use of issuing, accepting payment for, and executing a bundle of digital rights or utility. So this whole process has been automated through ICOs, and I think that didn't exist a year ago. It certainly wasn't used a year ago, and I think that's a particularly exciting proof of concept for smart contracts.
Sorry, yeah, here at Clause.io, we are working on implementing blockchains for use with smart legal contracts and blockchains or blockchainy technology in the sense of may not fit the definition of blockchain, could be distributed ledger, something more broadly conceived, or just something more decentralized. And I think it's not so much about blockchains per se, as that a term that's given these days, I think, to refer to a wide group of technologies, including sort of distributed file storage, distributed networking that may not exactly chain data and transactions in quote-unquote blocks. And I think that's the sort of important question to ask, is not so much if it's Ethereum or Bitcoin per se that you're going to use in some way, but sort of what is your approach to decentralized computing, which I think is sort of the future, including with open source technology. And the Accord project that we're also launching through Clause is trying to answer and develop standards with respect to open source tech and standards and uniformity to some extent that's needed in the smart legal contract space. And I think ICOs are a great example of sort of use case for that approach to standards and why it's needed, because certainly things are working now, but there's probably an approach that can be improved upon to the extent that parties sort of agree upon how things can be structured and implemented, whether it's on a blockchain or not. And through just sort of being an academic, also sort of teaching and writing about blockchains and relevant technologies, and becoming sort of an advocate for thinking about things from a technology point of view, which I think everyone in this room is already on board with, including, again, through a decentralized approach, which I think makes sense for a lot of reasons, but not every use case, and also open source, which I think is just a necessary component of the future, and now, of course, too.
Pat?
So at Consensys, pretty much everything we do is blockchain based. We do everything from startups to working with large corporations, nation states, cities, really just kind of run the gamut of everything you can imagine in terms of blockchain based technologies and solutions. And obviously the crossover between what we're doing, what we're imagining, what we're hoping to do, there's a lot of crossover with laws and regulations, both existing and what we might want to have in the future. So we spend a lot of time, number one, trying to understand what current legal frameworks are, regulatory frameworks are, and number two, we also spend a lot of time thinking about how these frameworks can be improved to really take into consideration the possibilities that blockchain can really unleash for not only the companies and countries and things that we're working with, but really just kind of society in general. So we really view it as a really important thing to be thinking about and working on. We're also, kind of more specifically, we're working with one company, a startup. It's called Open Law. That is, it's just launching. It's really exciting. It's kind of a next generation smart contract. It deals with open source contracts and automated signing and execution of smart contracts that are embedded within the contract. So we're really excited about what that can do for the legal industry as well.
Great, thank you. Nina, you have a role that is fairly kind of a new role that's emerging, which is you're the head of legal engineering at Monax. Could you tell us what it entails to be that legal engineer or head of legal engineering, and just what path you took to wind up in that role?
Sure. Well, the first thing is we sort of felt like we needed a different term to describe what we do. We're very legally sensitive in all of our work, but it's different to execute technology that you think will work for broad use cases than to practice law, because for legal engineering, at least at this point of the technology, we're more dealing with advanced process engineering. What are the systemic functions that are common and horizontal and cut across use cases? And how do those things need to be able to work in order for X, Y, or Z use case to exist? So that might mean anything from deconstructing a problem in order to design a solution or a system, sourcing humans and technological solutions to cobble together what needs to happen to make this big problem be solved, because usually the solution is not contained within any one entity's wheelhouse. But then it also comes down to executing with a team of varied subject matter experts, developers who all have very high-level skills or just granular skills too, domain expertise in their particular segment of the stack, figuring out how we all coordinate it all together and then make sure it's going to pass a lawyer's smell test. And so, yeah, it's a really fluid job. Yeah. But it is the most fun job I can ever imagine having as a lawyer. Right. And it's almost as if I get to play Lego with the universe a lot of days. And it came from, after 18 years of practice in pretty small law, I saw that blockchain could solve a lot of the solutions that made, that number one, made it easy, that could make it easier for more entities to be included in the economy, to reduce some of the barriers that my clients, who might be small or medium-sized businesses, had vis-a-vis my clients that were the biggest banks in the world. I graduated law school before e-signatures were a thing, so I'm just right on the cusp. So the standard of care in commercial litigation was so low back then that 6 weeks after the bar exam, I got thrown out to try a jury trial solo for a global finance company. That standard of care is unacceptable, I think. I mean, it went okay, but that's not, the entities rightfully began to push back on law firms using their matters to cut their associates' teeth. So over the years, those entities who had the understanding and ability and willpower to execute legal technology systems coded out my job, number one. So that particular cutting your teeth on litigation for finance companies, they're not paying for that anymore. That job is gone. But we've come to a really sophisticated level of legal process automation. Blockchain is going to allow that revolution in both value chain optimization and legal services delivery to a much broader spectrum of commerce, not just my clients who could afford anything they wanted. So,
thank you. I wanted to just sort of do a quick question, just like one or two words from each of you on what you think were some of the greatest technological advancements, blockchain technological advancements in the last year. Just like what's sort of top of mind that is the best. And maybe we'll start down there with Pat, if you're ready.
ERC20 tokens.
Great. Do you want to explain what an ERC20 token is and why it matters?
I'm trying to follow directions, yeah.
Sorry, it was a good one.
No. So ERC20 tokens, it's a little bit what Reuben touched on earlier, just within the last year. An ERC20 token is essentially a standard for creating what are called tokens. You've also heard ICOs, initial coin offerings. Some people call them coins, but essentially they're these digital representations of really anything. I mean, they're fundamentally programmable assets. They can represent a tokenized stock or a bond in a corporation. They can represent a beer debt. They can literally represent anything you can imagine. And this has just all kind of come into fruition in the last year and really opened up some really exciting new business models and ways for capital formation, like Reuben touched on. And I think it's just the beginning of what we've seen in the last year.
Great. Houman.
Yeah, maybe not so much technology from my point of view, but initiatives like consortia that have developed. Like, I do think the Enterprise Ethereum Reliance, the IoT Consortium for blockchains also is good and important because beyond any specific technology, it gets people talking and collaborating and being open about what they're doing. I think for the long term, that is really important for the blockchain ecosystem in general and just the economy as a whole.
Great.
I got to agree with Pat. This last year is all tokens. That's the hugest development in my mind as well. If I can answer the question in a different way, next year I would predict the biggest technological innovation is going to be blockchain governance. We've seen problems with the Bitcoin network and disagreements fundamental to the existence of Bitcoin recently, and so we're going to see new models emerging. There's new blockchains being built with governance mechanisms. So that's my prediction.
For me, the most exciting things that have happened haven't been the ones that get a lot of press releases, and those are the people that I would definitely call legal hackers, whether or not they have a JD or not, who have taken this technology, analyzed a commercial system, found a place for themselves in it, and put out a production model that actually gets them enough revenue to keep the lights on. So those are the people that I think are going to be most transformative, but they're not the folks that we're hearing a whole lot about. It's really exciting to hear about the consortia and the huge amount of awareness that we have, but my bias is I'm geeked about the use cases.
Dazza. Yeah.
Cool. I think over the last year in particular, the big news for me has been, well, some of it people have already said, like one-liners that are good for technology, but the stuff that I've used mostly would be components that would allow people to have a job title with the word engineer, like Nina, who are also lawyers. And so there's been the maturity of components that are composable within a system so that you could begin to support and reflect the requirements of, say, a transaction or even a business model with reusable components. So what I'm thinking about, number one, is a bunch of systems, kind of like what Nina was starting to hint at, where there's a smart contract on a blockchain that represents the boundaries of the system. So there's a couple of solar panel like grids, that one of which I'm involved with, where the whole thing's set up on a smart contract. So the energy creation is metered and tokenized, the usage is metered and tokenized, the payments, and your lights go off if you haven't paid after a certain amount of time. I think modeling Nevada utility law or whatever. And that's cool. So now you've got coterminous boundary point for a legal business and technology system with these weight-bearing beams of identity and transaction and units of value, all of which align in the contract and the governance and the system. So having composable pieces like key pairs that we can use to sign things, and smart contracts that are conceived of as what I would have probably done as a consortium or a bylaws or some kind of like trade association agreement in the past, are terrific composable pieces to actually apply this technology to business, legal, and technical systems.
Yeah, I'm going to throw in that I think the advent of self-sovereign identity that isn't associated with a server as an actual thing in the world is progressed quite a bit in the last year, and so I'm curious to see how that evolves. And to come back to that, actually, for you, Dazza, do you want to talk about some of the advances around digital identity that are happening?
I do. When you were saying it, I was thinking, I hope we can talk about identity. I mean, arguably, that might have been what all of us talked about, in terms of what's important. And it's not popular yet. I don't think it's really hit like above the fold of news, but there's tectonic things coming together to cause, number one, an address on a blockchain, like what you would get if you had a wallet on Bitcoin or Ethereum, to people understand how that can be an identifier and a usable endpoint for digital identity. Humongous. And that's the essence of the digital signature app I was mentioning. More to the point, utilizing that to represent a role, such as I live in a system like a community that uses this energy system, and
Right.
to, for my utility bills, or to agree to changing the bylaws of how we'll be governing disputes or what have you, or just to sign, like a statement or an invoice, really, really actionable. And then finally, what people are trying to do in, I feel, more applied ways now, to allow the address on a blockchain for any person outside of a role or context, but just because you're a human and you have an address, you generate a key pair one day, as is your autonomous right as a free person, not as like property, to let that serve as the root identifier that you can bring to a government for the beginning of, say, I don't know, like a passport or a license, or you could bring to an employer on the first day as part of like I-9 onboarding. You could bring to a university to get a university account, something that is yours, that adheres to you as an autonomous person, that consents to be governed and can revoke consent. That's a great usage of a distributed system that no single government or power can shut off, and that has perfectly good public-private key pair that we can use at an address that we can point to. So I think that's the big news, is people are figuring out how to digest and use the service and the components for identity in the big sense, but also in the narrow sense, like as in a role as an employee or a transactor in a system.
Yeah. Does anybody else want to weigh in on that? Yeah.
So I completely agree that the idea of a self-sovereign identity is really exciting. One of the things we're doing at Consensys is we're working with a company called Uport, and they're doing several interesting projects, but one of them is actually they're doing a pilot program with Zug, Switzerland this fall, where Zug is actually going to recognize these the Uport blockchain identities for their citizens, and that can obviously open up a whole world of possibilities in terms of the way Zug can kind of deliver government services, and even do things like voting or whatever. There's just, the possibilities are really fascinating. And the other thing I would add to the self-sovereign identity discussion is it really has the ability to transform the way we interact with the internet as well. Currently we have our personal information stored on a whole bunch of different websites, whether it be Facebook, Google, whatever. And they kind of own our identity in a lot of ways, but the future of self-sovereign identity would allow us to maintain our own personal information. We control it. It resides on kind of our side of the internet connection, and we can selectively disclose what we want to whom we want. And as this idea of self-sovereign identity catches on, I think you'll see more and more products and web platforms where they accommodate that. So instead of, for example, needing to give Facebook all of your information to register, there very well might be, say, a social network where you disclose, what you want to whom you want, but the actual network itself is not housing that information of yours. So I think it's really some fascinating potential, and it's definitely an exciting area.
Did you want to weigh in?
Go ahead.
Okay. I was going to ask next, Reuben, could you tell us a little bit about, I'm going to jump onto this topic of ICOs and how tokens are used, because it's such a hot topic right now. Reuben, could you sort of describe to us how regulators are determining if a blockchain token is a security or not?
Sure. So I think until very recently, we hadn't seen much action at all from regulators in the space. But what had been going on is a continuous process of education on the part of regulators and them understanding the technology. And I think in particular, the SEC spent a lot of time trying to understand the technology and its potential use cases before issuing a report in the last couple of weeks. And then we saw this a similar response from MAS in Singapore. So basically, looking at any particular token, which, as Pat mentioned, could represent theoretically any asset, any bundle of rights, any real-world asset or blockchain asset, looking at the characteristics of the asset behind the token, the use to which the token is put, and the reason for which the token is sold. So looking at all of these surrounding circumstances to determine whether or not a particular token is a security. And just to put a bit more clarity on that, if people are using tokens to try to raise money that looks like issuing equity in a company, then that's going to be a security, right? We have the Howey test, it's well established, and it's pretty clear application. The challenge, I guess, is when we see tokens that represent things that don't look like any traditional financial instruments. They look like a right to use computer processing power or file storage or decentralized identity, and any number of use cases that don't currently exist. So I guess the SEC in particular sort of explained that not all of these tokens will be securities, but that securities law generally applies to blockchain-based tokens just as it does to any other instrument or contract.
Right. Houman.
Yeah, that shouldn't be too surprising. I think that the SEC's explanation was pretty expected and pretty straightforward with what is sort of securities law 101, the Howey test and the factors. But nonetheless, it has introduced some, I think, skittishness probably on the part of would-be ICO utilizers. And nonetheless, I think for people in this room, it still could be a great method of collaborating on a project. I use that phrase instead of a great method of raising money, because if that's the case, then maybe not. Maybe just a simple Reg D or traditional crowdfunding may be a good way to go about it. But if there's something that exists, it's a platform that's already out there also, as opposed to something that's only in white paper form. If there's something that is out there, it could be a really good way to bring people together to get the sort of grease the wheels running on it.
And do you guys want to put some more color on what would constitute an access token versus a security, or if there is a difference, something that might be outside of the current framework?
So I think generally it's all still, nothing's black and white, right? The SEC said this particular token, the DAO token, was a security. They didn't say that any other token was or wasn't a security. But to your question, I guess, the divide that we're thinking of it, we put out a paper last year together with our friends at Consensys and a few others, looking at whether the token has an actual use case, right? It's sold like a product. It's sold because the people who buy it want to get access to this decentralized application. So people are referring to those as utility tokens. They do something. On the other side of the divide are things which just, okay, I'm giving you the profits from this company. You get a share of the profits, right? So those, I guess, two sides of the spectrum are kind of maybe more clear, but then there's any amount of things in the middle that make it harder.
Great. Who else wants to weigh in on that?
Yeah, I'll just echo. I mean, I completely agree with what Reuben's saying. I think that we at Consensys, I think we were not surprised by what the SEC said, and I think we were encouraged by the overall approach that the SEC communicated. Focusing on a case-by-case analysis, recognizing that there are very legitimate use cases for these types of token sales. And in terms of the difference between utilities and security tokens, I mean, as Reuben said, I mean, there's just the possibilities are endless for tokens. So it's hard to articulate a clear dividing line, and that's in part why it's encouraging that the SEC is saying we're going to take this on a case-by-case basis. But in terms of the utility tokens, one thing that you can see. Some of these utility tokens they function more as almost like a software license, right? Like they have the effect of essentially letting you access and do certain actions and things on this kind of next generation platform, and it's not even just necessarily accessing it, but the way the tokens can be defined, they really the users can really kind of be intertwined with. And become a part of the system as opposed to simply being, invested in the system or being served by the system. So I think that's one of the really exciting parts of this whole movement.
Can I offer a couple? I think needed to.
Go ahead.
So this actually is a good entry point to a time-based, kind of like survey. So one of the major things I think that did happen over last year is this crisping up of now, I think, a discernible dance between the regulators and, in particular, the ICO aspect of blockchain use. That's a real good way to start the next year. So once there's a kind of a cadence and a rhythm, you can begin to make judgments and narrow and identify and move forward. There was a lot of, I don't know what, like kind of like Walking Dead kind of like shuffling in random directions, and that's scary to me in terms of relying on, with big investment in technology when people aren't talking the same language and you're not in a dance with the regulators. So that's big. But now looking forward, I think it really comes down to some of the questions that were just addressed about identifying the nature of the asset. And so I think what we're going to see next year is a much better agreed sense of articulation between, and I'm going to just throw a word out here that hasn't been used, but a resource at the highest level, like the R in URL, like a resource at an endpoint that you can access. That could be an access right, like to gain access to a document. That could be, 10,000 shares of stock. But it's a resource that's at an identified place that you can do something with. Very generic. Then we need words for the type of resource that's fungible, property that's owned, and it's maybe of a security type, or maybe it's of other personal property type, like my poem or my song. And then we need words for other types of utilities, like CRUD, like it's an access right, or it's a different type of right that nonetheless exists absolutely at an endpoint that we can interrogate and operate a system based upon. So I think beginning to apply first-year law school concepts of property and ownership rights and obligations to digital resources, and then becoming more articulate about how they break down to assets that are securities and other types of property that we can have rights to that can be exchanged, is what I see developing next year.
As a person who was in small law, I look at how I would approach this from like sort of a bottom of the stack point of view, instead of creating securities that are going to work globally. Well, I apparently don't have any hobbies anymore, because all my hobbies are now, how do I make blockchain use cases? So the one I'm working on right now is, how do I answer some of these questions that we're talking about with ICOs? And that we've got a problem with crowdfunding and accessing crowdfunding in the United States, and it is becoming very clear that we have some jurisdictional issues to work out in order to be able to get this global network working. So we're working on, I'm working on regulation crowdfunding in North Carolina that is intrastate and relies on a specific SEC exemption that I think 147A that is only so far explicitly enacted in North Carolina, that gives us a lot more freedom from an internet perspective, and a lot less freedom on how much money we can raise. So there's a cap. But nonetheless, to articulate these small business open crowdfunding models in a way that is compliant and then scalable across US jurisdictions so that we can meet global requirements is a necessary step to reaching all these pie-in-the-sky use cases, like you were talking about with the solar panels and things like that. How do people access the resources to get their community into that system? And it's community-based crowdfunding. So that's what I'm working on.
So I want to, how many folks again are from outside of the U.S.? Are here from outside the U.S.? Decent amount. So, I mean, I think the SEC rulings in the U.S. are particularly important, and they also seem to extend out to, anybody that's selling into the United States. But I'm curious how, let's see, maybe I'll actually start with you, Dazza, again. Yeah, just like how are the different jurisdictions that are out there, how do you see those playing out in the future? Like, we have a town in Switzerland that is called Zug, which is attracting a lot of new folks. There's Gibraltar and Mauritius, et cetera, that are kind of taking up the charge around blockchainifying their infrastructure, and some of them aiming at being more ICO friendly. So I'm curious how you think that will play out in the next year.
I'm sure. What? Just slightly more crisp. Like,
yes.
What aspect of?
Well, so in the U.S., the regulatory framework is very clear, whereas in these other jurisdictions, they haven't formed the same regulatory frameworks,
okay,
and so I'm curious how you see that as playing out. And,
okay.
and yeah.
Thanks. I almost answered the wrong
Sorry.
question. All right. Well, I'm just like rank speculation, but I would imagine it wouldn't be so different from, history to this moment, and that it would look something like some jurisdictions might follow pretty closely what we're doing, and that we can expect to see some real experimentation in some, where you've got political and other reasons, where conditions come together such that there's a new kind of model. And most of those will probably die. Some might survive, and we might see evolution in the models of regulation because of the laboratories of innovation we have in transnational law. I think there'll be some cool questions that come up in terms of capabilities of blockchain to allow better application of existing regulation, including to maybe have more context-sensitive ways to identify what jurisdictions apply to what layers of the transaction. So that will be interesting, and conflict of law things will be a laugh a minute.
Sure, yeah. And Nina, do you want to weigh in on sort of what ways that the blockchain itself may be able to assist investors in evaluating what to invest in, or whether it's a safe investment? Some of the roles that regulators might ordinarily do.
Well, I think the SEC they gave us a fair number of guidelines on that. And I think there are folks here that have done really eloquent statements of what you should be looking for. Kyle Mitchell's one of them over there. Yeah, lots of folks here, I'm sorry. So a lot of folks have talked about that, but you have the Howey test, you have what you're going to use it for, and I'm not sure I remember the question.
Yeah, I'm mainly thinking, like, let's say you live in a jurisdiction where, let's say you don't have the benefit of the SEC acting in your favor, and you're interested in using a blockchain. Are there some affordances that blockchains offer us that are similar to the way that regulators function?
Are there some what?
Affordances of blockchains that are possible to sort of fill in that gap for blockchains to be as efficient as some of the regulatory pieces in regulating those ICO markets?
Sure, but in real life, what I see is that it's more a matter of the regulator working with the blockchain to make sure that the regulator is being as soft touch as they can, but at the same time, they have a responsibility to make sure there's not an ongoing fraud in their jurisdiction, so they can't yet afford to be completely hands-off.
Right.
And so that's more where I'm seeing how do you make the regulator's job be really seamless and not very burdensome, while still trying to protect all of the individuals in the system that is being regulated. And so that requires a balance between regulator perspective and user perspective.
Sure.
And so everybody has to be at the table.
Right. Pat?
Yeah, so I would just add, at Consensys, one way we really think about this is, our mission is really to further the blockchain ecosystem, and we recognize that we're not going to be successful building a successful blockchain ecosystem unless we achieve a lot of the same goals and ideals that the regulators are actually trying to achieve. Things like protecting users or people that are on the blockchain, things like rooting out fraud and things like that. These are the goals that are fundamentally driving regulation and policy in all jurisdictions. And they're also goals that we who are creating apps and companies and things on the blockchain that we also share, and that I think we have to achieve if we're going to achieve real success with the blockchain ecosystem generally. And so there's a lot of and I guess to take that one step further, the point is there are a lot of really interesting innovations and use cases that we can perhaps come up with that accomplish a lot of the goals that regulators also want to achieve, leveraging these new technologies and innovations. And I think that's going to be a really exciting area too.
Right. So in the absence of clear regulation, I guess we're seeing some best practices emerge, or like we're learning lessons from past failures. So as the crowd sales for ICOs have emerged over the last few months or this year, we've learned lessons, right, as a community from crowd sales who haven't got their smart contract code audited, or who haven't set the right caps on how much money they want to raise or how many tokens they want to issue. And I guess we're, as a community, learning some of these lessons the hard way, albeit, but we're seeing this best practice emerge. So when the time does come for regulation, it's not emerging in a vacuum. We have some industry development as well.
And what is so cool about that, the rate of error, learning, correction, is the blockchain space is evolving so incredibly fast. Each time they make a leap forward that actually addresses a problem that they discovered. So while we've had a lot of lawyers, myself included, standing back going, oh, that's not gonna work, that's not gonna work, and okay, inevitably there's some crash, they fix it, they move on, they're learning, and they're doing it so much faster than we did before blockchain and network economies.
One very quick one. I was just thinking, well, that's a good question. Like what, and I was just listing out, what are the capabilities, what are the commands that I could run and what do I get back, and how do you map that to specific regulations, but also the purpose of the reg? One is, and I noticed the SEC really harped on this with the Dow opinion recently, that you want to know if someone's an accredited investor, you want to know if they have a lot of money and if maybe therefore can be treated less with kid gloves. Well, be a piece of cake inside a cryptocurrency to say, well, show me proof of possession of a lot of money. Sign something from accounts that in the aggregate have over some threshold, considered a lot, and then different lower key rules could apply for all of those people investing in your ICO. That'd be a simple one.
Yeah.
Digital signatures for consent and for acknowledgement, and legal notice, I think, is the big undiscovered country too.
Yeah.
So I feel like there's a lot of rudiments. Well, there's a means of exchange. It's actually sort of a playground. That's a great question.
Yeah, thanks. Cool. I want to jump over, just switch topics. We've just Bitcoin has just forked into two currencies, and Houman, maybe can you describe what the fork is and why this Bitcoin fork matters?
Yeah, sure. I think it matters if you're a holder of Bitcoin, but I mean, you can, in a very broad level, and you can look at it as like a network upgrade, assuming you agree with the approach that was taken with the fork. But the idea is that with blockchains, or at least particular ones, and perhaps public ones in particular, there is a limit to what they can do. And in this case, there is a limit by design to how much memory and essentially transactions the Bitcoin blockchain could process. And in a sense, that's a good thing because it keeps what is being processed sort of clean and neat and straightforward. But the limitation on that is that there's only a certain amount of transactions that can be processed. There's a limit that was being reached, and then therefore the amount of types of use cases you could use the Bitcoin blockchain for was inherently limited. And for example, you hear a lot of complaints by players in the financial industry that the Bitcoin blockchain is just nowhere near suitable for the amount and speed and volume and velocity of transactions that they would want to process to obtain the benefits of a blockchain. So there was or was not, depending on perspective, a governance mechanism by which to achieve the consensus, no pun intended, required to increase the block size or to change the fork the Bitcoin blockchain. And so that's what happened very recently. And most people, I think, and there's certainly disagreements about whether that ultimately is a good or bad thing, but most people, I think, would think that was a positive development, and certainly other people on the panel here can chime in on that. But that kind of brings us back to the idea of blockchain governance or governing open source software, maybe more generally speaking. And I think it also comes to the idea a little bit of, you talked about like a bubble in ICOs. You do want to think about, is there a bubble in sort of blockchain hype? Certainly there's a ton of interest in the technology, which is, I think, appropriate. But for any particular project or company or whatever it is, I think you do want to ask yourself, is a blockchain really needed for what I want to accomplish? Or maybe, and maybe in 5 years you answer that question differently, given the state of the technology in 5 years. Or are the costs not worth it? Or can I achieve similar goals, like a reduction or a lack of a central point of failure through other means by not using a blockchain or using something else? So it's something that, like any new technology, any change or upgrade, you just want to weigh the costs and benefits of everything.
Great. I'm just going to do one more question, then I'm going to go to your questions. I just wanted to ask Reuben, how does the SEC's investigative report of the DAO change or clarify the role of cryptocurrency exchanges? Because it sort of...
Yeah, so from our perspective at Coinbase, we operate, we have Coinbase, which is the easiest place to buy and sell Bitcoin, and we also have GDAX, which stands for Global Digital Asset Exchange, an order book platform for professional traders. So on both of those, we have to think about which assets we want to trade, which assets do we want to make available to our customers, and there's a bunch of different criteria around that. I mean, you have literally thousands of different digital assets, some of them worth very little at all and with very little use. So as Coinbase, adding any particular asset is our stamp of explicit approval of that asset for trading. And so we need to consider not only the security and the demand behind it, but also some of the regulatory issues, like is this token a security? So I guess we at least have some clarity from the SEC now about what types of things would most likely be a security. So that weighs into this sort of multi-factor decision that we would make.
Thanks. I want to go to audience questions now because we're kind of winding down the time. I just want to make sure we get some of your questions. One single question. Okay, no pressure. This guy raised his hand first. Yeah, I'm sorry. Right, how much Bitcoin do you have?
I guess my question is, how does the panel see the evolution of governance on blockchain, especially globally, given that anything that applies to the blockchain applies to all of the participants, and as sovereign entities become more aware of it and become more involved, differences in opinion between, say, China, Russia, US, how is that going to kind of force the evolution of blockchain to either be global or have different pieces all over the world?
Who wants to get that one first?
I'll have a go. So one of the benefits is that an open public blockchain is not controlled by any corporation, government, or group, right? One of the challenges is that it's not controlled by any corporation, government, or organized group. So you have this distributed consensus mechanism, but every time it comes time to change or upgrade the rules of consensus, then we have the same problem that Houman just described, and we just saw with the recent Bitcoin fork. So I guess to answer your question a little in a different way is that the challenge for upgrading these and changing the rules of consensus is the governance challenge itself, separate from any sort of legal governance in that sense.
Pat, do you want to?
Sure. I think this touches on some really kind of interesting, perhaps even philosophical issues in terms of, you get into political philosophy and things like that even, but one idea that I think blockchain governance touches on is the idea of the ability to kind of govern by consent versus governance by coercion. And the really cool part of blockchain is that you're participating in a blockchain entirely voluntarily. It's entirely by consent. And so you can, in theory, have tens or hundreds or thousands of different blockchains governed by their own sets of rules and protocols that anybody can come up with. And if it's a good system of governance, more people can consent to participating in that platform. And I think the why that is so cool is because it allows you to achieve consensus without necessarily uniformity. There can be a lot of different ways of going about things. And if you contrast that with a system where it's just kind of everything's mandated for everybody, I think there you get, in theory, kind of coerced consensus, but or you have you have the uniformity. Everybody's doing the same thing, but you don't really have genuine consensus as to this is the right way to go. So I think that moving forward, the ability to kind of govern each other and ourselves by a matter of consent is going to really open up a lot of cool possibilities.
Right. I think, just to jump in, I think that there's two things that blockchains have already done well that are international. One is the setting up the economic, this is for permissionless blockchains, setting up the economic incentives for chains to maintain their own existence, and also that the cryptographic elements of preserving your own private key work no matter what jurisdiction you're actually operating in. And so I think we may see soon other core constructs that are necessary for governing organizations across multiple jurisdictions that are sort of like primitives about how at least permissionless blockchains will operate. I think on the other side, we're going to see clusters of notaries that are located in specific jurisdictions, so that we can guarantee that a particular transaction takes place in a particular jurisdiction, and that's more kind of the ledger route rather than the permissionless blockchain route. So I think we'll see both of those.
Can I offer a challenge, I guess?
Yeah.
So I didn't have the faintest idea what the answer to your question was until these guys spoke. But it was very illuminating, I thought, and it sparked an idea, which was to understand better what the answer to the question is and how to align different governance schemes to the technology. Because honestly, the way we do miners in Bitcoin and the way Ethereum set up is hardly the only way you can do it. People are experimenting with a lot of different systems now. What if we had like a legal hackers pack where we took, say, just because many of us are familiar with it, the US Constitution, and then maybe did a profile of it, like a simplification, maybe like reduced it to a tenth of the back and forth. But you've got like 3 branches, you've got the origination of like a bill or a policy, you've got 2/3 for the veto, you've got the umpire who can change state. We could actually model that, and then you can imagine the documents they're doing. Hell, it could be a contract, it could be a policy for an agency, it could be a bill for appropriations, but it's a governance system. It's really well engineered. If you ever deconstruct the Constitution with like a pencil and just be like, what are the roles, what are the interactions, what are the dependencies, what's the sequence, what are the triggers, what are the state changes? These people were good. Like they thought this through. It's tight. It would be interesting to try to do that, not like in Perl or in C++, but why not do it as a smart contract? And as the essence of the underlying blockchain. So you'd have a consensus mechanism that aligned to the sources of power. Every individual user is consented, and then blah blah blah. They call into existence the system, and then you've got like some states. Maybe that could be their local departments. You've got the federal government, and you cycle it through explicitly supporting and reflecting rules that are written down. We could all get a copy of it. We all kind of understand it, and we could model it and do it, and then learn more about how to apply any arbitrary governance scheme to a consensus mechanism in a blockchain, and then get a vocabulary and some capability to do that.
Yeah. Great.
Challenge.
Okay, so I think we got to wrap it up. Thanks for a great final question, and thank you to our esteemed panelists.
I got some final notes before we leave. Okay. Sibilance. So a few notes. First, just to give you a sense of how global this conversation is, not only with legal hackers, but also even today. Someone who is participating in the conversation today on Twitter sent me a direct message. His name is Kuda Hove. He's from Harare, Zimbabwe, and he's interested in starting a Harare, Zimbabwe legal hackers chapter. So we're having an impact today in what we're doing. 4 other things. The first is that before we break for the day, I want to follow through with our commitment to show the 2 videos that were put together from Kenya and from Singapore. So we'll be showing those. It's 10 minutes of content. If you could give them 10 minutes of your time and listen, we'd really appreciate it. So we're going to do that before we break for the day. And tomorrow we kick off at 9:30 in the morning with some amazing presentations. Aileen Schultz from Toronto, Kat Moon and Franklin Graves talking about design thinking, workshops on SQL, as you heard, and a focus group on legal innovation itself. Who are legal innovators? What makes them tick? What makes these communities grow and strong? So that's all happening. So with that, thank you all so much for coming for the first day. I had an amazing time. I learned so much. I hope you did as well. And let's look forward to these 2 videos, starting with Nairobi, if we can, and then to Singapore.
hackers in 2016. It's such a great experience. We've had a number of events. The first thing we wanted to do was to sort of engage ourselves in the local community so that we could provide whatever assistance we could. We realized that there are several legal gaps, and we felt that the best way to plug in was to get engaged in as many activities as possible. And hello, legal hackers. Greetings from Kenya. Rosemary from Nairobi Legal Hackers. Since we started Legal Hackers in 2016, hello, legal hackers. Greetings from Kenya. Rosemary from Nairobi Legal Hackers. Since we started Legal Hackers in 2016, and it's been such a great experience, and we've had a number of events. And the first thing we wanted to do was to sort of engage ourselves in the local tech community so that we could provide whatever assistance we could. We realized that there are several legal gaps, and we felt that the best way to plug in was to get engaged in as many activities as possible, and we've had quite a number of them. The first and foremost, we had the fireside chat in conjunction with the local Google office, the head of legal public policy, together with the Center for Intellectual Property and Information Technology, where we hosted an event and we discussed the internet and the law. And it was really amazing. We had some really great feedback. The second event, we've also taken part in the Nairobi Tech Week and also DevCraft. These are very huge conferences where techies come together. And we as legal hackers felt that we needed to come in and actually meet people who are actually in the space and offer whatever advice we can, legal solutions for their problems. We also had a Hacks and Hackers event. The legal hackers worked in conjunction with Hacks and Hackers, and the topic was in regards to think before you post. Yeah, that was really interesting because you see, in Kenya we have a very vibrant internet community, and people always post things on Facebook, on Twitter, and we felt that most of these things have legal implications. How can we advise Kenyans on the best way to engage in a positive manner? And that was really successful. We're together with journalists, and we were discussing internet governance, law and ethics in regards to publishing, reposting, what are the implications, cyberbullying, and all those other kind of issues. And then we also participated in the African Women in Technology. One of our members, Juno Carl, represented. She was a speaker at the event. And yeah, it's amazing, and we were very happy that we had a lawyer actually getting to speak on behalf of women in technology in Kenya. And then we also took part in the Kenya Internet Governance Forum, where we as legal hackers discussed the future of the internet, right from all different perspectives in regards to fintech, blockchain, and we've actually developed an interest in some of these topics, and we try give policy guidance on technology and the law. And then we also took part, most recently, there was a mishap in the Kenyan tech space, and legal hackers, NBO legal hackers, took it upon ourselves to draft a sexual harassment policy, which we hope will be adopted by the tech community in Kenya. And what we did was create a standard, a document, which we feel that tech companies can actually plug into, adopt, and even refine and tweak. And I think for us it has been a big win. It has, I think, our greatest contribution in the tech space so far. That we just saw that there was a problem, but we didn't just sit back. We actually took a stand and said, look, we're going to come in, we're going to put in some time and actually create precedent that can be utilized by the tech community, and we're great to have left that mark in Kenya. And we've also had a meeting where various ladies in tech came together and actually analyzed the document. It's an open document in Google Docs where we're allowing people to come in, help, even edit, offer their suggestions. But so far, so good, and we're very glad that we took the bull by the horn, so to speak. And yeah, we're making a change in Kenya and in Africa. And we're glad to be part of the Legal Hackers community. And we hope to, one of these fine days, actually attend an international conference where we can actually get to meet most of you on a one-on-one basis. And we wish everybody all the best. Asante sana, that's thank you in Kiswahili. And have a great conference.
We're from Legal Hackers Singapore. My name is Jian, and I'm currently in the process of getting called to the bar in Singapore. And together with me are my friends, Josh and Dima. Hello everyone, I'm Josh. I'm a legal policy officer in the public service, but of course I'm speaking about this in my personal capacity. I was previously legally trained. I studied in the Singapore Management University School of Law, and that brings me to Danielle.
Hi, I'm Ting Yao. I'm currently a law student at the Singapore Management University.
I was from the National University of Singapore. Anyway, so today we're here to share with you a bit about our what we've done here in Singapore with Legal Hackers. The interesting thing about Legal Hackers is that we have quite a huge amount of overlap in terms of members with this other entity called Outlaw. Essentially, we're just wearing two hats because we realized that sometimes when we mention legal hackers, people start thinking of some kind of that we are subversive, or there's a bit of connotation over there. So we decided that when we are facing, say, ministries or university groups and things like that, we use this name called Outlaw because it's slightly more neutral. And I will first talk about what we've done in terms of the lobbying or engaging as one of the stakeholders for the future of legal industry in Singapore, and then I'll let Danielle and Josh talk about the projects that we do. So in Singapore, the good thing is that the government is very proactive in pushing for legal innovation because they want to make sure that the legal industry remains competitive. So they go around usually for each of the initiative, engaging different stakeholders so that they can have a holistic view of what's happening. And that's how we've been involved in the Courts of the Future program, which is driven by the Singapore Judiciary. We've been involved in the program, the initiative by Singapore Academy of Law, which has published this thing called the Legal Tech Vision, which I encourage everyone to take a look at. And also, we were involved in a consultation group for the future, as a committee of future economy in Singapore. And we also were invited to speak and discuss with the Senior Minister of State for Law, Ms. Indrani Raja, to talk about basically what the future lawyers and potential lawyers think the future of the legal industry is going to be. So that's how we get involved, and we have been very fortunate to have these opportunities to help work with policymakers to ensure that the policies that are being laid down currently is favorable for innovation and that we can all move forward together. Nothing else.
So in order to help law students like myself prepare for the technological revolution ahead, some members of Outlaw have gone on through the universities to establish student chapters there. These student chapters serve as platforms to allow law students to connect to legal tech practitioners as well as lawyers who are also interested in legal tech to learn more about what might be coming ahead for the legal industry. So besides serving as platforms, some students in these student chapters have also conducted coding workshops where they also learn to not only be good at handling the legal code but also computer code. So some members of Outlaw have gone on to form startups. One such example is Lex Quanta, which is a legal analytics startup. So now I'll pass my time on to Amelia, who is in Thailand. Amelia will talk about Law Tech Asia, an online review initiated by some members of Outlaw.
Hi, I'm Amelia and I'm a law student from Singapore. So one of our initiatives is an online publication called Law Tech Asia. Essentially, we realized that there are a number of online sites that publish legal tech news in other parts of the world, but there's a lack of coverage on legal tech in Asia, and specifically Southeast Asia. So that's where Law Tech Asia comes in to fill that gap. So essentially, we hope that with better circulation of information about issues at the intersection of law and tech, we can raise awareness of how legal practitioners, policymakers, and law students aspiring to careers in law and tech can take that first small step in adopting a legal tech solution, and ultimately advance the idea that legal tech is something that should and can happen right now.
Hello everyone, so back to Singapore. Thank you, Amelia. And what she's covered is the other things that Law Tech Asia has been doing, as well as the purpose of Law Tech Asia. So I'll add on a bit more and cover a bit more in detail about the things that we've been doing in Law Tech Asia. Of course, so all this is done outside of my work, and what Amelia and I do is to write thought pieces about the legal developments, legal tech developments in the industry. Recent articles that we've been writing include the an article on how the law firms, law offices would look like in the future. We've also written about online dispute resolution and also how the legal profession for lawyers, young lawyers, will look like in the next 5 years. At the same time, we've also been working with professors and other people overseas to co-write articles and share ideas about legal tech developments. So for example, we are currently co-writing an article on online dispute resolution with a professor in Vietnam. We're also working with Mr. Vroom. He's the previous founder of Modria on something related to online dispute resolution as well. So we're still very new. We're still in the process of looking at what are the things that we want to cover in the future. So we'll be very happy to welcome any sort of feedback and comments that you have for us. And in fact, if you guys are interested in any collaborative opportunities to co-write articles, we'll be very happy to link up with you and share some ideas and work something out together. So that's on the online side. Now, on the physical side, we've also been doing something as well. So we have these things called legal tech meetups, which I'm sure you guys have it over there in wherever you are as well. In Singapore, what Outlaw and Legal Hackers SG is doing is to bring together, for now, university students to discuss recent developments in legal technology, as well as to get them to think and follow up on the legal technology developments that are happening from week to week, from month to month. Of course, in the future, we are looking to expand this to cover other people as well, legal professionals, for example, legal startup entrepreneurs, and even members of the public. So to bring up the awareness about legal technology in Singapore. So we'll be very, very happy also to see if when you guys come over to Singapore, do let us know when you're coming down. We'll be very happy to extend a hand out to you and let you join us and share about some of your legal technology developments in your country as well. So that's from me.
All right, that's about it. Thank you so much for listening. I hope you all will have a great summit over there in New York. And hopefully someday we can join all of you, or maybe we can have a Legal Hackers in Asia summit in Singapore, wherever it is. And that's it. Thank you so much. Bye-bye.
Bye-bye.